I'm Dave Hansen, and I am up first. So I thought before I got into the meat of what I'm going to talk about, I should introduce Authors Alliance and myself a little bit. I'm the executive director of Authors Alliance. Our mission is to advance the interests of authors who want to serve the public good by sharing their creations broadly. We have about 2,400 members, a pretty good number of which are academic authors, all of which have a really strong commitment to libraries. And we're regularly involved in trying to support the work of libraries because it directly supports authors as well. In that same vein, my role with Authors Alliance as executive director, I actually started in that role last summer. And prior to that, for about 6 years, I was at Duke University as an associate university librarian there, overseeing our research and collections services. So just a little background on where I'm coming from. And what I want to talk to you today about is how fair use fits in with the rest of the Copyright Act. And in particular, the rest of the limitations and exceptions that you find listed here. I thought this would be a good place to start because knowing that this is a room mostly of librarians, I hope you can appreciate the value of going to the table of contents. This is essentially the table of contents of the kind of core part of the Copyright Act that we're often dealing with. And so I'd encourage you to read this. The Copyright Act is actually pretty accessible as far as federal statutes go. You can read this through and it's not like a foreign language. But what you'll find is a pretty basic explanation in the first 5 or 6 sections of the Copyright Act, explaining what is protected by copyright, what's not protected. So for example, Section 105 says that works of the United States government are not protected by copyright, just a sort of say-so thing in there. But there are lots of other nuances that are helpful to understand the scope of rights. And then on the tail end of Chapter 1 of the Copyright Act, you will find a whole list of limitations and exceptions. And so the structure is, look at that Section 106 there, it gives the exclusive rights of copyright owners. So it says that they have the exclusive control over reproduction, distribution, public performance and display, and creation of derivative works. And if all you did was read that section, it would sound like copyright owners have just like crazy broad control of their work. If you took those terms literally, it would pose a lot of problems for the work that libraries do, and creators and others. And so what Congress did was they set up this structure where they said, we're going to grant these really broad rights, but we're also going to include checks on those rights, limitations and exceptions to those rights. And that's what you find littered throughout the bottom part of this chapter. And these can get very, very specific. So for example, Section 111, limitations on exclusive rights, secondary transmission of broadcast programming by cable. Like we never deal with that. It just doesn't come up. So a lot of these are just super particular to particular industries. Some of these actually get used quite a bit though by libraries. So for example, Section 121 there at the bottom, limitations on exclusive rights, reproduction for blind or other people with disabilities. That's actually a big deal for us and for libraries as well. Authors care about that because they want their books to be available to as many readers as possible. And so having the ability of libraries and other institutions to make those copies in accessible formats is very, very important. And of course, that's important for libraries, right? To be able to meet the needs of their users. Other ones that might be familiar in here, Section 110 of the Copyright Act talks about exemptions for certain performances and displays. There are some really funny things in Section 110 if you read it, where you'll see like, that's where the lobbyists showed up. And there are exceptions for agricultural exhibitions and things like that, like just oddly specific performances. But you'll also find exceptions in there for core teaching and instruction uses, using works in front of a classroom. And then, of course, Section 108. Section 108 is really important for libraries. Section 108 provides basically exceptions for libraries to make preservation copies And it also allows libraries to make copies in certain circumstances for research support, for things like interlibrary loan and copies for users. It also includes a couple of other interesting things like when Congress extended copyright by 20 years in the late 90s, they included this provision in Section 108 that said, well, libraries can still use some of those works if they're in their last 20 years of copyright protection, and they go check to make sure that they're not being currently commercially exploited. So Section 108 does a lot for libraries, but one of the questions that comes up is, how does fair use and Section 108 go together? How do these two pieces fit? And it's actually come up a handful of times in discussion at the Copyright Office and once, at least, in litigation. So Section 108 is kind of an interesting part of the act in that it's very important for libraries, but it doesn't often get litigated. I did a check this morning, and there are only about 40 cases total that even cite to Section 108 in its 40 plus years of existence. So about one citation per year. And if you read those citations, about 2/3 of them are just acknowledging that Section 108 exists. They're not actually applying it or even interpreting it. So it doesn't get used very often. And so it leaves open a question of like, how does Section 108 fit together with fair use? These very specific exceptions that libraries have to make particular copies for their users or for preservation purposes, as contrasted with the very broad and flexible exception that fair use provides. So you have a few different options, I think, for how to interpret these two sections together. Option number one might be that the specific overrides the general. And there's even like a nice little Latin phrase for interpreting statutes that way, to say when there's a specific declaration of how things should be, that should override a more general statement. So the logic there is, well, fair use provides this general exception, but libraries have this very specific thing. And so that's all that they get, that very specific exception. That was actually an issue that was challenged in court at one point, and we'll see how that came out. So option number two is that they're just unrelated and we just read them separately, and that's just all that there is. And then option number three is kind of an interesting one, and that I think there's a very strong argument for, which is that the specific should influence the general. And so where this kind of rubber meets the road in terms of application of the law is that sometimes we're using Section 108 and trying to understand how it fits together with, for example, in the preservation sections of 108, it says that you can make a certain number of copies. It says you can make 3 copies in certain instances. Well, what happens if you make 4? Are you then doing something illegal? And that's where you may be able to say, well, I don't technically fit within Section 108, but I think that the general principles of fair use will support this because of some of the principles articulated in Section 108 for libraries. So Section 108 has this really nice provision, actually, that gives us some guidance on how Section 108 library exceptions fit together with fair use. And it says that nothing in this section anyway affects the right of fair use as provided by Section 107. Or contractual obligations. And so that gives us some hint, right? It seems to indicate that the rights of fair use as provided by Section 107 shouldn't be affected. And so maybe that means that option 2 is the right answer, that like these things are just separate, that they shouldn't be considered together. But I think it certainly indicates that option 1 is off the table, that libraries have access both to fair use and to the specific limitations and exceptions that are provided by Section 108. And this is actually an issue that has been litigated. I said there haven't been much litigation, but there is a little bit. And this came up in the case Authors Guild versus HathiTrust, which is a lawsuit about HathiTrust, a bunch of university libraries that came together and created a large-scale digital library. The Authors Guild essentially argued that the only exception to copyright that the libraries could rely on in that case was Section 108. And Section 108 said that you can only do things like, make 3 copies for preservation purposes in certain circumstances. And the court said no. Section 108 F4 means that actually they can still argue fair use. which is really, really good. And actually reflects back on some of the, or addresses some of the initial fears that libraries had when Section 108 was being created. They really worried that the courts would say, this is all you get, and you don't get any more, you don't get fair use. But fortunately, in the one case that we do have on this, it indicates that Section 108 does not limit fair use. Congress also said this in a few places in the legislative history, reassuring us that it's not meant to take away rights under the fair use doctrine. And so just bringing this back to fair use, one of the things that we're asked to think about in fair use is the purpose and character of the use. And I think that means that we're supposed to be thinking about things like, is the use nonprofit or educational? Is the work transformative is one of the things that courts often looked at there. But there are a handful of cases that analogize uses that would seemingly be close misses under some of these other limitations and exceptions, like things that closely miss Section 108 that would mean that it would be viewed favorably under the fair use analysis. And I think that also matters when thinking about a use that is in general in line with the purposes of copyright. And what better way to get a sense of uses that are aligned with the purposes of copyright than to look at the types of uses that Congress has authorized under other sections of the Act. So that's it for my slides. The main message I wanted to get across here is that libraries have a lot of tools in their tool belt to allow them to make reasonable uses of copyrighted works, to serve their users, to make copies available to the blind, to preserve works. Fair use is a really important part of that. Libraries have other tools at their disposals, but they don't limit fair use. And in fact, I think there's a good argument that they enhance their fair use case.